Start. Even though in the interim order dated 7/5/2010 passed by the High Court, there is an indication that the question of refund of amount with interest would be examined at the stage of conclusion of the writ petitions, in the circumstances as has unfolded and noted above, when there was no adjudication and determination with regard to the right of the appellant and a declaration that the amount was illegally demanded and retained by the respondent, either the direction to pay interest or to compensate in any other manner for the pendency light period would not arise, full stop. However, insofar as the non-refund of the amount for a longer period even after the expiry of the period permitted by the court, admittedly the appellant in the first of the above cases has initiated separate proceedings, full stop. In that regard, all contentions are kept open and none of the observations made in deciding the issue herein would prejudice the parties in seeking adjudication of their contentions therein. Full stop. Apart from the fact that the appellant in the second of the appeals has failed in the proceedings before this court in an earlier SLP, insofar as the pendency light interest, in view of the conclusion above, the same would apply to their case as well, and for the subsequent period they may avail their remedy, full stop. Insofar as the order impugned in the second of the above appeals, it is seen that the said order dated 15/10/2009 is arising out of the contempt proceedings, full stop. Contempt case number 326 of 2020 was filed alleging willful disobedience of the order dated 27/8/2002, whereby a direction had been issued to refund the deposit which had been made, full stop. In that light, the appellant had sought for a direction, to be compensated, full stop. The High Court, while disposing of the contempt petition, has taken into consideration that there was no adjudication on merits and, therefore, the payment of interest or compensation would not arise, full stop. Be that as it may, as rightly contended by the learned counsel for the respondent, by placing reliance on the decision of this court in the case of Prithvi Nath Ram versus State of Jharkhand and others, within bracket 2004 7 SCC 261, relating to the scope of the proceedings in a contempt petition and in a circumstance where subsequently the amount has been refunded and the contempt, if any, to that extent is purged, the ultimate conclusion to dispose of the contempt petition by the High Court, in any event, is justified, and we see no error committed so as to interfere, full stop. However, insofar as the contention relating to the retention of the money belonging to the appellant in the second of the cases herein subsequent to the expiry of the period indicated in the order dated 27/8/2012 passed in WP (C number 2823 of 2020) before the High Court, and as to whether such retention has caused loss to the appellant and conversely the benefit derived from the same by the respondent, if any, and the manner in which the same is to be compensated or not, as also the rate at which it is to be done, are matters which would have to be considered in appropriate proceedings and in accordance with law, wherein the parties will avail all opportunities to put forth their contentions and place material, full stop. Therefore, in a similar manner in which the appellants in the first of the above appeals have availed their remedy, it would be open for the appellant in the second of the above appeals also to avail the remedy before the appropriate forum, in accordance with the law in the matter, full stop.